I'm going to try and do my best to continue the theme here, but I'm going to look at the issue of IP investments and IP assets from a slightly different angle. And rather than look at the this one. Oh, I see. Okay. Sorry, let me just figure this out here. Okay. So rather than look at the actual creators of the assets, what I'm going to look at is the IP investment in human capital and the people behind the innovations, the people behind the actual sales of a product. Because in the end, these are the people who actually add value to a company. And I think just based on our collective experience, we can all agree that there's a certain subset of employees in every company that are highly skilled and highly valued and who are the key drivers of innovation. There was actually a very interesting French study done a number of years ago which looked at the proportion of U.S. patents that included a prolific inventor. And a prolific inventor was defined as someone having 9 or more patents. And what the study found was that there was clearly a population of prolific inventors, especially in Germany and Japan, where prolific inventors were responsible for 66% and 94% of the patents granted, respectively. And even though I'm going to be talking about trade secrets rather than patents, I think this is really instructive for showing that within every organization there really is a key subset of employees which really drive value and innovation, and recognizing that we all live in a highly mobile global world, the question becomes, how do we protect these assets, and how do we accept the fact that inevitably these key employees are going to leave the company at some point, and so how do we protect the value that they've created from going to our competitors? Now, some people have put the annual cost, at least for U.S. firms, for trade secret theft as much as $300 billion. And not surprisingly, trade secret litigation in U.S. courts has been growing exponentially over the past few years. You'll see from 1988 to 1995, the trade secret cases in U.S. courts doubled, and then doubled again from 1995 to 2004. And at the current rate, by 2017, trade secret cases will be doubling again. And the vast majority of these cases, 93% of these cases, are cases where the misappropriator was an employee of the company or a business partner. And the vast majority of those cases as well involved commercial trade secrets. Now, commercial trade secrets can be distinguished from technical trade secrets, where the commercial value that's being stolen are not necessarily technical, but they are such things as customer lists, business strategies, marketing strategies. So these are the vast majority of cases that are being litigated in U.S. courts. So, this is really an area of the law that doesn't get a whole lot of attention, partly because it's an intersection of not only IP law, but also contract law, employment law, as well as ethics. So I'm just going to set forth some of the guiding principles here in the limited amount of time that we have. This issue has really reached the forefront over the past few years for a number of reasons, but one of the reasons is that technology is allowing employees to take massive amounts of data with them when they leave their employer. So you can imagine situations where someone leaves the employer and within a matter of hours or minutes can take entire customer lists, client lists, marketing strategies, business strategies, and use that to the advantage of their new employer. You can imagine, someone leaving a key salesperson at a company who has been responsible for millions of dollars of sales, and downloading his contact list right before he leaves, and using those contacts to drive sales for his new employer. Is that acceptable? Is that legal? Is that ethical? the most common way that this issue has been dealt with in almost every jurisdiction has been through contract, especially in India, where trade secret law is really governed by contract. There's no separate trade secret law. And the most common type of contract that this is being dealt with is a non-compete agreement. Now, or confidentiality agreements, but non-compete agreements would be the typical way that this issue has been dealt with. Now, in the U.S., non-compete agreements may or may not be enforceable. It depends on the jurisdiction. But in many jurisdictions, they're enforceable if they're necessary to protect a legitimate interest of the employer. Now, of course, that legitimate interest cannot be the employer trying to stifle competition and trying to prevent his competitor from gaining this information. The legitimate interest is typically the interest to prevent trade secret theft and other types of unlawful behavior. So if there is a legitimate interest, typically those types of agreements are enforceable, but they also have to be limited in scope. You can never prevent an employee from going to a competitor for forever. It has to be limited in time, and it also has to be limited in geographic scope. Now, some jurisdictions in the U.S., as I mentioned, disfavor non-competes, and they're unenforceable. California is one jurisdiction, and just due to public policy reasons, California has a very strong public policy of employee mobility, and they've taken the view that unless there is trade secret theft, that there is no enforceable contract which can keep an employee from moving to a competitor. Now, of course, TRIPS, as we're all familiar with, defines a trade secret in very general terms, and the definition in TRIPS is that the trade secret, first of all, has to be a secret. It has to be the subject of reasonable steps to maintain secrecy, and it has to have commercial value because it's secret. Now, of course, all of the WTO members have to implement their own national strategies to carry this out, but some countries are still in the process of implementing this. So contract has typically been, by and large, the primary vehicle for dealing with trade secret theft. Now, most people, of course, think of trade secrets as technical trade secrets, but the commercial trade secrets, as I mentioned, are really the most vastly litigated types of trade secrets. So I've just set some examples of the types of commercial trade secrets which are the most commonly types of litigated, at least in the U.S. courts. And if you look at U.S. state court cases from 1995 to 2009, the commercial trade secrets actually made up 70% of those cases. So now in the U.S., you can prevent customer lists and information. You can protect them as trade secrets only under certain circumstances. So, for instance, if your customer lists are published, for instance, and many of us work in law firms, you may publish your client lists on your website. Of course, in those circumstances, the identities of those customers will not be a protectable trade secret. There usually has to be something more. So if you can imagine situations where you have you're privy to your client's confidential information, such as not only the identity of the customer, but let's say you know the key contact people within that organization, how decisions are made, the annual IP budgets, and how the organization works. That type of information clearly gives you a competitive advantage, and that type of information, at least at U.S. courts, has consistently been protected as a trade secret. Now, the next step to establishing a trade secret in this type of situation is that you have to take reasonable steps to maintain secrecy. And typically, the most common way that this is done is through confidentiality agreements. Most courts have said if you have employees sign confidentiality agreements, that's typically enough to show that you've taken reasonable steps to safeguard your commercial trade secret information. Another way is to mark documents as confidential. Of course, that carries the drawback that if you don't mark certain documents confidential, they may then not be protected as trade secrets. Of course, other ways are limiting access to your confidential information, either through computer passwords or physical security measures. But in the vast majority of cases, confidentiality agreements have really been the primary way that that businesses have safeguarded their confidential business information. And this was from a study done a few years ago where it looked at cases from 1995 to 2009, and at least in 11% of the cases, the confidentiality agreements were the primary tool. Now, usually it's really a combination of measures that courts look at, but the confidentiality agreements are usually, by and large, the preferred way. How do you establish that that the actual information has commercial value? The question here becomes: did the employer expend substantial resources in coming up with the customer list or customer information? And the key question here is how much resources were expended. And generally, as a general principle, the more resources that are expended, the more likely it is that the information constitutes a trade secret. And the question is, does the confidentiality of that information actually provide a substantial business advantage? Now, the remedies for this type of misappropriation are generally the same as in many other types of IP infringements. You have monetary damages and injunctive relief, but the key question when it comes to trade secrets is, can you get injunctive relief before the misappropriation actually occurs? Because this is a type of situation where once the trade secret theft happens, it's very difficult after the fact to really cure the irreparable harm that automatically results. So the answer is it depends, and it depends on the jurisdiction. Some jurisdictions in the U.S. Recognize a doctrine called the inevitable misappropriation doctrine. PepsiCo versus Redmond was the key case, which actually involved commercial trade secrets. It involved marketing strategies and business strategies. But the requirements to establish this, and there's only certain jurisdictions that recognize it. California has actually rejected it for public policy reasons. But if in the jurisdictions that recognize this, you can actually prevent an employee from going to a competitor. And the three requirements for proving this is: first, of course, the employee knows the first employer's trade secrets. The second requirement is that the duties at the first job are so similar to the employer's duties at his second job that inevitably the trade secrets would be disclosed. There's no way they couldn't be disclosed. And there has to be some bad faith element, because typically this is considered a restraint of trade. So typically, unless there's some bad faith, courts are very unwilling to prevent people from seeking employment. Now, I just want to end by just going over a few, practical tips for both employers and employees who deal with these types of issues. At a minimum, these types of issues should be addressed in either the employment agreement or a separate confidentiality agreement or an NDA. And at a minimum, the agreement should, put the employee on the specific types of information that the company considers trade secrets. There's a lot of cases which say, if all that's in the contract is, you agree not to disclose our confidential information, the courts have said in many cases that is too broad and too vague, and that will be unenforceable. So it's important to go into some level of detail spelling out what types of information the company actually considers a trade secret. Of course, you'll want to have a provision in there requiring the employee to return all of the company's confidential information at the end of employment. Many companies now, as a standard matter of practice, are implementing exit interviews for all employees who have been exposed to the company's trade secrets, where they're reminded of their confidentiality obligations and where the employer collects all of the confidential documents and makes the employee sign an agreement recognizing that you've returned all of the company information. This has the advantage, if this is litigated, then it has the advantage of, in addition to a trade secret misappropriation claim, there's also a potential breach of contract claim if the employee signs that type of document. So it's just another level of protection. For high-level employees, for key employees, many companies now, as a matter of practice, are searching the employee's computer, especially in companies where trade secret theft happens on a regular basis. They review deleted files, files downloaded to external devices. This typically happens after employees leave. And as a matter of practice, many companies are, for all employees, they are imaging their employee's hard drive just to preserve that for future litigation. And of course, once the employee leaves, you'll want to continue monitoring the marketplace to see if there's been any shift in either in your competitor sales, whether there's been a change in strategy. This is all kind of an area where the evidence is indirect until you actually get to a litigation. So you want to pay attention to the marketplace after one of your key employees leaves. Now, some practical tips for employees. A lot of people, when they're leaving a company, they send announcement letters saying, "Okay, now I'm moving to company X. If you'd like to discuss anything, please contact me." That type of announcement letter, courts have actually found that could be considered solicitation and violate a non-solicitation clause if there is such a clause in the agreement. But the general rule of thumb is to only discuss business with your former employer's customers if you're invited to do so. So it's very important who initiates that business discussion. And of course, if there's no trade secret information used, the general rule is that you are free to go after your former employer's customers, but it all depends on what type of customer information you're using. If it's just contacting the customers, then it depends on how that contact is initiated and what type of information is used. Of course, if you have pre-existing relationships with people where, let's say, you had clients before you even came to your first employer, and you've maintained those relationships, then those types of relationships you can continue. Thank you very much. If there's any questions, in the interest of time, I'm happy to take some questions afterwards. Yeah. Actually, I just wanted to mention one thing. Finnegan, where I work, we are having a mock jury trial at 4 to 6. We hope all of you can join us. We have some flyers in the back, and we all hope you can make it. Thank you.